Jane, did you find all the responses that I've been sending you when you sent me shit? Is Jane in here? I thought she was.
He's in here somewhere.
I am. I just had to walk over here and take off mute. Yeah, I think I got one response to one of the things I asked you about.
Well, if you sent me anything since last Thursday, I haven't seen it.
I've sent you plenty, but I was going to file my motions today, but I realized one of them I had on the order, I had it labeled wrong. So I'm going to file them tomorrow. Motion to eliminate and motion to suppress.
Well, I know I responded back to the last motion in limine I seen and the motion to suppress. Did you read it?
If you did that today or...
Well, I did that before I got hit by lightning.
No, then it's not even the same motions anymore.
Well, then that's very helpful because that's the last one I seem to have from you.
No, I think I've sent them to you. You just haven't seen them. Let me see here.
What is the date today? September 4th. The last thing I have from you with an attachment to it is August 25th.
Okay, was that after Thursday?
Damn, Jane, I don't keep a calendar in my head. I don't know.
I don't either.
That's before last Thursday.
August 25th was Monday before last.
All right, let me see. Because I don't know, but I don't know how your stuff got in the spam folder. I sent you, August 25th.
Yeah, exactly. And I responded back to it, not once, but twice.
I did not see the response. And I still haven't. One of them is 7. Okay, so it's a little bit longer, the motion to suppress, but I'll have to see where your response is. I haven't seen it. I've been looking all week for responses, but I've not been getting anything in Proton mail for some reason. And then I looked and I saw you were in the trash. And I wouldn't even look, but Julie said something about it.
There is the response that I sent you on August 25th. The same day you sent it to me is the day I replied back.
Okay, August 25th. I don't have it.
We'll check your spam folder again.
Yeah, I'm looking in the spam right now.
You might have to refresh your email to get it to download.
Oh yeah, I do have it in the spam. I haven't seen it yet. I just not see it.
Then before you take it out of spam, click it, and then at the top, mark not spam, and they'll stop going there.
Okay, well, usually I'll do that. Let's see here. So anyway, what else?
What do you mean, what else?
Well, I'm filing it tomorrow regardless. I mean, I have no choice because it's going to, the date is coming up. I'll look, see what your thing says, and
Did everybody get the video of the last mock trial we did?
Yes.
Okay, and how Jane was complaining that this isn't how they're going to do it in the courtroom because they're going to ask all these other questions?
I don't remember saying that.
You did say that in class. You said exactly that.
Yeah, I said it's not how they're going to do it, but I don't remember saying the other part. Anyway, go ahead.
You said they're going to ask all these other questions about qualifications and all this kind of stuff. My question to you, Jane, is what does any of those questions do to prevent you from raising the defense the way we covered it?
Okay, any of what questions? You talking about in the motion to limine?
So we're talking about in the questions you were complaining that the prosecutor is going to ask their witnesses when they get them on the stand about who you are, how long have you been doing this, what's your job title, et cetera, et cetera, et cetera.
That doesn't. But what the way that you did, I don't know if you listened to the cross or not, but the way you did the cross was leave out. I mean, there was no foundation at all for me to even ask anything about. So.
Okay. Let me lay this out for you. We know there are specific questions a prosecutor must ask a witness when they're trying to prosecute a criminal case. It's a given. If they don't ask them, then you can jump all over that. But if they do, which we assumed in our mock trial that they did, then where I came into it is on the assumption that they had to have laid the groundwork because they need that as a basis for proving the charge.
Right, and that's how you did your cross.
I know that, Jane.
Yeah.
Okay. The point being that the questions I didn't ask as the prosecutor, I left. So we didn't take 3 hours to do the class, which we did anyway. I did it so that we could get to the crux of what your defense is and show you how to do it. The defense does not change regardless of how many other questions the prosecutor asks the witnesses, Jane. And we know for a fact that they have to ask the questions that we presume to have already been asked when I did the cross, because they can't establish the ability of the witness to even testify to them until they ask them. So given that, stop focusing on all the superfluous shit and focus on the crux of what I keep trying to tell you about the ordinance. What they have to actually prove and what you have to do to prove they can't prove it. See, there's a misnomer about innocent until proven guilty, okay? And there's a misnomer about presumed innocent until proven guilty. You do not have to offer evidence proving that you're innocent.
Exactly.
But you do have to offer evidence proving that they have failed to prove you're guilty.
Exactly.
Okay? Now, in a lot of ways, that's a distinction without a difference, but it is the distinction. So basically, you don't have to prove you didn't do something. You just have to prove that they never proved you did.
Right.
And so my line of questioning on the cross-examination was geared to doing exactly that.
Right.
Because remember, we only have to kick the legs out of one part of any number of elements.
I know, but a lot of your questions on the one for Hollinger, it was like all this training, long drawn out questions about training, about, for the officers.
On
and
cross or on direct?
It was on cross.
Right. Assuming that, we wanted to go the long drawn out route. But the more I've thought about it, the more I'm like, look, we don't have to do that.
Then why did we do that? Was the last thing we did. So that's what I've been focusing on.
It isn't. I didn't go into all that last time.
On the very last one we did, when you did the, what do you call it? The Columbo one or whatever. That one, you didn't. And I don't think.
Right. That was the last one we did, Jane.
I know, but I can't. So then I don't have to do all that long drawn out bullshit. Then
No, you don't.
Because that was
my point in all of this is say, look, there's multiple ways you can attack this problem. Sure, you can challenge every little thing they say and do, but all you're doing is pissing off the jury and delay and making it a longer time for them to have to sit there and listen to this shit.
Right.
And you're not going to make them happy.
No, I don't have a jury. I have a judge.
Again, doesn't matter. Yeah. It doesn't change what they have to prove. And it doesn't change what you have to prove they didn't prove. Okay? So quit being nitpicky and just pay attention.
Okay. All right.
Now, who's got anything they need specifically to talk about?
I do. So I've been going over that motion that we talked about in the last email. I'm not sure what parts you're referring to that I need to remove. I'm not really certain on that. Can you elaborate a little bit? Okay, so it was about the
anything that isn't specifically relevant to the facts of your case needs to come out or be changed to make them relevant.
So, for example, within that particular motion, it talked about DWI and DUI. So I need to remove that, correct?
Yes.
Okay. That's what I'm trying to make sense of. Because I was asking Julie about it, and she was kind of helping me through it.
Well, so again, you're not being arrested for a DWI or DUI.
No,
so
I was being arrested for a offense that is not even codified.
Correct.
When y'all get done, I got two questions. I got two things that happened, and I almost forgot about it. Was the
hold on, we haven't finished our discussion yet.
That's the only things I was curious about as far as that's concerned. I want to make sure I understand that so that I don't.
If we're making any specific statutory references or logical references that could be applied to your case, those you can use. But anything dealing specifically with a DUI or anything like that is irrelevant. It doesn't need to be there.
Yeah, because from what I was talking with her about is that it seemed like that within that statute, that it was, or not the statute, but the way the Michael Morton's Act, it seems to be where it just is only applicable to DUIs and DWIs. But in reality, it can include any of those elements when a person's arrested. Is that correct?
Which one of those? Okay. This is just so y'all can see.
Yes.
I want to put this up on the screen. I'm not going to put the email up there, but I am going to put the text of the email up there.
We took the liberty to make it into a Word document too, so I could work on it.
Okay. All right. Can everybody see this?
Yes.
What I told her was to study the Code of Criminal Procedure regarding the Michael Morton Act as it pertains to discovery. The prosecutors are intentionally misrepresenting what the statutes actually say in regard to disclosing video evidence in discovery. Prosecutors are misrepresenting the meaning and purpose of Texas Code of Criminal Procedure Article 39.14D. They are claiming that this subsection means they are not required to provide copies of, among other things, photographic or video evidence to pro se defendants. But that isn't what it says or how it works. The withholding of copies of certain evidence codified within Texas Code of Criminal Procedure Article 39.14D applies only when the evidence consists of sexually explicit child sex materials or it has been judicially excluded from admissibility, which requires an evidentiary hearing and an order from a judge, not simply a prosecutor's refusal to produce. For example, if certain parts of a piece of video evidence are ordered excluded from admissibility by a judge, then the state is not required to provide copies to a pro se pro se, though that is just as much a due process rights violation as refusing to provide it at all. If the evidence is of the more explicit variety, then it stands to reason that the photographing and duplication would not be permitted even though review is. The way they are reading it allows them to refuse to provide copies of anything they want, despite the production requirements codified in Texas Code of Criminal Procedure 39.14a, which is a clear indication that they are reading and interpreting 39.14d incorrectly, because A says they will provide all of this kind of material. So for them to turn around and read D to say except for this, when that same shit is listed in A, is a misreading of D, because A and D are in paramateria. Therefore, they must be read as a whole.
But let me ask you this. So in reality, they're just doing that on purpose and hoping I'll never catch it.
They're all doing that to everybody on purpose and hoping they'll never catch it, especially pro se's. In other words, the prosecutor can't simply say no and point to Texas Code of Criminal Procedure Article 39.14d while claiming that you have to just accept their interpretation at face value. If they do that, then argue this interpretation of CCP Article 39.14d to rebut it. If they rule in favor of the prosecution, then we do an interlocutory appeal to get a judicial determination on which interpretation is actually the right one. And we have the right to the interlocutory appeal because the trial court is not applying the law to the facts. And because they are misstating the law, we are not getting access to evidence we're entitled to for our defense. Thus, it's a due process violation. Thus, we have a right to file an interlocutory appeal. Got it?
I got it. Thank you.
But they have to read 39.14d with 39.14a, b, and c, and every other part of 39.14, and possibly more than just 39.14. But anything dealing with evidence through discovery would be in paramateria to this section of the statute. So it all has to be read together. They can't read it in isolation, and that's what they're doing.
Would that apply to like disciplinary records of police officers?
Only certain personal information of the police officer,
Like factual basis?
unless state law prohibits that from being available through discovery, which I don't know how they could get away with doing that.
Right. Just, or like whether if it resulted in disciplinary action or not, is that still required for them to hand that over?
I don't know. It depends on the state you're in as to what the state law says. In some states, the disciplinary records are public records and they can't prevent you from getting them. In others, they try to protect the cop.
Right. Well, here in Indiana, they allow the public access to disciplinary records. However, they only allow that access if the end result is like they have been suspended, demoted, or something like that. Something has come from that disciplinary action.
You mean you don't have a right to see how they were disciplined?
It's only like the factual basis of it if something has come from that. Like if they're, like, for example, if there was an
Well, if you're suing a cop for excessive force, you have a right to know whether or not that there have been complaints filed on that cop for excessive force. And you need to know whether or not the department has ever done anything to prevent him from doing it again.
Right. I just got a FOIA request back from my local sheriff's department because I'm actually looking at getting ready to sue a police officer. And they told me that because no disciplinary... Pardon?
Did they give you a law?
Yeah, it was Indiana Code 514.3 something.
And did you read it?
Yeah.
And does it say what they say it said?
Yeah, they can't release anything to me unless something happened as a result from their investigation on that officer. So,
in other words, they had to substantiate the allegation for the evidence for you to be able to get anything relevant to it.
Yeah, and some disciplinary action had to have been implemented. But if they were like investigating him or any public complaints on the officer, there I could have used against him towards his credibility in court. I didn't have access.
The thing about it is you might not be able to get them through an open records or a FOIA request, but discovery is a different thing.
Right. I had requested it in discovery when my case was ongoing, and the prosecutor had told me that there was no such records that existed, and I am actually just now finding out that there are records that exist. They just
okay. Well, that's prosecutorial misconduct and secreting of evidence.
Yeah.
Potential exculpatory evidence.
Yeah.
I'd bar grieve the prosecutor for that.
Yeah, I have already. I'm getting ready to file another bar grievance on her as well.
Well, I'd also file a motion for sanctions with the court.
Even though my case is over.
Well, again, if the prosecutor is intentionally misleading the court needs to be made aware. So what I'd do is I'd still file something with the court, a copy of the bar grievance or whatever I sent in, notifying the court that this prosecutor has a habit of lying to pro se's about what records there are that they're asking for in discovery.
Yeah. Okay. I even have the emails exchange with her when I was asking for those disciplinary records.
Good. Attach them to the bar grievance and to what you give to the court.
Okay, I'll do that.
One of my questions has to do with that, records also, open records.
Okay. Well, let me finish the train of thought here and then ask a question to her before you move to yours, Jane.
Well, I thought
Now, here's the thing. You said that you have records showing that they do exist, even though she said they didn't. What do you have that shows the records you wanted exist?
I have the paperwork from the sheriff's department when I put in my FOIA request. I requested.
That's what I thought you were going to say.
Yeah.
All right. So now let me say this.
They left me breadcrumbs, basically.
Well, the thing about it is breadcrumbs does not a loaf of bread make.
Right.
Not unless you collect all the breadcrumbs.
Right.
All right.
Well,
so here's your problem. Okay. The fact that they say we can't give you such records is not proof that there are such records. Those are two different things.
Right.
They can very well be saying, well, even if they did exist, there are these kinds of records, so we can't give those to you.
Right. However,
that's not an admission they do exist.
Well, there's two officers that I requested the records on. And one page, they have the one officer, and on all my requests on those types of records, it says that no records exist. Well, on the second officer's page, under the same categories that I requested, they give a big explanation that those records are confidential. But
that's still a different officer. So why are you conflating the records that exist for one officer with records that exist for the other?
Because I would think that if
well, there you go. That's the problem. You would think. Why are you saying that there should be records for the other officer if there is for this one?
Because they say on the one paper that no records exist. They flat out just give that statement.
Still doesn't tie the knot you want. How do you interpret this guy has records we don't want to give you to this guy doesn't have records that we wouldn't give you if they did exist? How do you say one means the exact same thing for the other? Were they involved in the same incident at the same time on the same call?
Yes.
Okay. And what happens if only one of them was the one that did the paperwork?
Then I guess he's the only one that they're going to look at.
So you've got one guy who we don't have any such records to give you. And then we have another guy with a long-winded explanation of why we don't want to give them to you. What does that tell me that it's not telling you?
Well, I asked for any disciplinary records that they had on either officer.
Okay.
Like whether it be public complaints or internal affairs investigations.
Okay, that still doesn't solidify the fact that there's paperwork on one guy, there should be paperwork on another. Because the cop that doesn't have any paperwork may very well not have either of those things. They didn't file any reports when they got back. The other guy did. They haven't had any disciplinary records. The other guy does. So again, how are you reconciling this to say you're not giving me what I asked for?
Well, I guess it's just a guess then, because
exactly. And therein lies the rub. You can't guess and file a complaint.
Right.
You need something concrete to base that on.
Well, if they're not going to give me that information, then how is one really going to truly know if there was an investigation done or whatnot if they're not even going to tell you?
Well, one of the ways to do it is petition the court to order that they be turned over.
Yeah.
And then if they leave them out, that's contempt of court. So in your motion for discovery, petition the court or file your discovery. When they tell you they don't have it, petition the court to order them to release the records because you believe that they're misleading you in order to secret evidence.
Okay.
All right. Now, Jane, go ahead.
All right, two things. One is I'll try to get I want to get a certified copy of the ordinance the two ordinances from the city secretary, and they refused to give me a certified copy. And
What
they
do you mean they refuse to give you a certified copy?
they said they don't have to get certified copies according to the Public Information Act. And I asked them to give me the specific legal grounds, and they said they don't have to. It was the secretary's policy. And I said, well, where can I find that? She goes, well, I don't think it's written down. And I said, well, I already have a call in to the Attorney General. I'm just letting you know that I'm filing a complaint. And I called Attorney General, and he called me back like the same day, and I missed the call. And then I've already called back 2 days ago, and he hadn't called me back. So, or the office anyway. It's not going to be him exactly, but so do they have? Without a subpoena. Without a subpoena is what they said.
A subpoena for a copy of a published ordinance?
Yes. Exactly what they said. Without a subpoena, I said a subpoena is used to summon someone to court. I says, are you telling me I have to have one for the ordinance, which is public record? And they said, yep, that's a city secretary's policy. So
yeah, well, that's definitely a complaint to the Attorney General's office.
Yeah, I told them the whole story on the voicemail, but I haven't got a call back. But that's one thing. The other thing, they said they left them. They said they did leave the ordinances at the desk up there, but they're not certified. So I know that it only takes a stamp to certify them, so it's not that big of a deal. They're just not doing it. So
well, it takes a stamp and a signature.
Yeah, but that's still not that big. It's not like it takes hours and hours to get something like that done. So anyway, the other thing is, I called that the place where I got the old speeding ticket from 2023 or 2021. I can't remember what it was, but it's been a while. And I called the attorney's card, the number on there, since there was no email, and they said, yeah, you've got 2 citations, and one's 30 miles over the speed limit, so it's real expensive, and the other one's failure to appear. And I asked them that I need to sign court order, and they said that I need to call the court. I haven't called the court yet because I really don't know what to say. I found the information from whenever I found a record of like me calling them, as far as like I wrote down like a timeline. And what it was I called the court. I tried to schedule a hearing, and they said the judge wasn't there and he would call me back. Well, the judge, he might have called me. I don't know if he did or not, but if they did call, he didn't leave a message or anything like that, and I didn't receive the call. So then I called him again one more time to schedule a hearing, and then and I left a message because nobody answered, and then they never called me back, and I forgot about it.
And this is how old?
2000 and I think it might be the beginning of 2023, but I'm thinking, let me look right quick.
You know what you remind me of sometimes, Jane?
What?
You remind me of a Looney Tunes cartoon where Foghorn Leghorn is laying in a roasting pan for an oven, and he's buttering his own ass.
Why is that? Why?
Because you're the only person I know that runs into these problems this often, this way.
Well, it's all the same problems I've had for all those years. It's not like new problems.
Obviously not, because this is up till now, I thought the only case we had going was the cat case, the feeding of the cat case, because we'd already dealt with all the other ones, including your old speeding ticket case you said you lost.
Okay, this is another speeding ticket.
Right.
Yeah, it is.
Stuff that keeps crawling out of the fucking woodwork years after the fact.
I know. Well, I told you I sent motions.
And almost always it's because you dropped the ball on something.
Well, on this one,
it's the Foghorn Leghorn buttering his own ass kind of deal in a roasting pan.
And this one I didn't even have. I think maybe I had just started your class, and I think I sent in Randy's motions, and I thought actually that it was over with, just like I thought.
It would be safe to say you don't even know what's in the court record.
I know that they have motions that I filed, but as far as anything else go, they don't have anything.
You don't.
I don't know what to say when I call them. That's why I'm asking you now.
Where are they?
It's in Cross Plains, Texas, which is about 2 hours from here.
Okay. Then why don't you ask them for a copy of everything that's in the court file, Jane?
Is that all I'm going to do when I call and talk to him? Because I want to say
filled out a form on their municipal thing.
No, they don't have any. They don't have anything like that. They don't have.
Then I'd have them email it to you.
They
Call
don't have
them
any
and
kind of-
ask them to mail you a copy of everything that's in the court file, Jane.
Okay, I will.
Don't tell them I want a copy of this, this, or this. Tell them I would like a copy of everything that's been filed in this case that's currently in the adjudicatory record, which is the court record, not the administrative record of the court, but the actual court case file.
Because you'd said before that I need to ask for a signed order from the judge.
No,
Okay,
not in this case, Jane. We don't know what they've got in the folder, Jane.
I know you don't.
So stop referencing what we talked about before and listen to what we're talking about now.
I know it always changes. So
Well, as the facts get divulged, of course it will change. Because
yeah,
I'm usually left guessing as to whether or not something is or isn't A, B, C, or D. And it's not until I find out which one it is that I can actually tell you more clearly what to do or not to do.
right. Well,
So as of right now, what we don't know is what's in the court file. And until we do know, we don't have a course of action to follow. Because what's in there will determine the course of action. You understand?
yes.
Okay. So we need to know what is in the court file. What's been filed? Because
Okay.
here's the problem. Did she say you have an outstanding warrant?
No, they didn't say that.
Okay.
I didn't ask either.
If it's been more than 2 years and there has been no warrant filed, and even more importantly, if there's been no actual complaint filed, then they're past their statute of limitations, and you can file to dismiss it immediately for failure to prosecute.
Okay, will they have had a complaint generated when they haven't done anything else? There is a citation.
Again, Jane, till you know what's in the court record, I can't answer that question, because if
Okay.
they did, it would be in the court record and we would be able to see it, wouldn't we?
Well, yes, we would, but they're
Well,
not.
until we see it, don't speculate.
All right, they're not a court of record, by the way.
Again, it doesn't matter if they are or if they aren't.
Okay, that's why I was asking. I didn't know.
We know what is in the court file. We do not have a next step to follow other than ask for a copy of what's in the court file.
Okay, and what if they say they're not going to send it to me?
Well, then that's a separate problem, isn't it?
Yeah.
Because now they're in violation of the public records, because those are public records. Court
Okay.
case files are 100% public. If they don't
Okay.
send it to you, that's a violation of the Public Information Act. That's an attorney general complaint on them right there. Make
Right.
sure you get the name of whoever you're talking to.
Okay,
Get the name of whoever you're talking to and the name of the judge of the court. And then if they don't give you the information you asked for out of that court file, then you file a complaint against the judge and whoever answered the fucking phone.
okay.
And we file it against both of them because of why?
Because she works for the judge.
Correct. And the judge is the person who's administratively responsible for everything that goes on in that court.
Right.
Therefore, if the clerks are not giving out the proper public information, that's because the judge told them not to, as far as we're concerned. Therefore, we get them for openly violating the Public Information Act, and we get the judge for telling them to do it.
All right, I'll call them tomorrow. Oh, I sent you those 2 motions, by the way, just now. I don't know if they're the same or not. I think they're not.
Well, I'm sorry to hear that.
Well, they're not that
means I
long.
got to read them.
You don't have to. I'm
No,
gonna-
I do, because if I don't read them, you're going to file them. And if you go file them and they read the way the rest of them's read, you're in deep shit.
Well, I didn't really think that I brought up stuff that wasn't relevant.
You never do, Jane. That's the problem.
Well,
You don't reason this stuff out. You just think and feel. Okay.
hear
And you
you,
base
Doctor.
everything you write on what you feel, not what
it
not what
has
the law
nothing to
is.
do with what I feel. Is what the
Really?
facts of the case are. Yeah.
Really? Okay.
Yeah.
Well, when I read it, I'll let you know if I agree with that or not.
Okay. Like the video, like doesn't have any evidence. Like the statements don't have any evidence. Like any of the stuff has no evidence.
Again,
Um,
we're not
okay, here-
arguing evidence. We're simply saying that what they're trying to produce as evidence, Jane, is not evidence of any crime.
Exactly.
The video
No,
shows no crime. The signed statement from the so-called witness that started all this does not cite a crime.
I know. Okay, I found the citation from the Cross Plains. Let me see if I can get it today.
And what was it for?
2021.
And what was it for, Jane?
It was for speeding. Let's see here. 58 Wait, no, southbound. Let's see. Damn, I can't read this. Okay, I found alleged speeding limit was 58 and I was going 58 and a 30. And dry roads, school, no, posted speed, yes, 30. Workers, no, day or night was day. Accident, no. Commercial, no. I was supposed to appear in front of Judge Don Gosnell in Cross Plains Municipal Court on 9/28/2021, and I called before then, and I think I called on that day of too. Let's see
Okay.
what
And any of that helps us how?
it doesn't. I'm just telling you that's what's happened, and then they never got back to me. They never sent me a complaint or anything. They had my address.
Well, there you go, assuming again.
I tried to. Well, that my address is on the freaking citation.
Again, Jane, there you go, assuming again. How many people have had their address on the citation and the court intentionally sends their shit to the wrong address so they get a failure to appear?
Well, that failure to appear that can be easily won anyway, but I'm not worried about that. I'm worried about how expensive it is for the speeding ticket for one.
Why?
Because it was like over $500.
That's if they prove the case, Jane. How are they going to prove the case, Jane? How many times have we gone over how to defeat a speeding charge?
How many? Oh, yeah, a lot of times. How many have we seen win that yet?
Well, as long as you're doing it, none, because you tend to give up and quit.
Well, I don't know anybody that's won a speeding ticket except for Brett.
I've won them, Jane.
Way back in the day, like 2013 or whatever it was.
Well, can I help it if they haven't written me one since then?
Can you help it that you haven't been driving since then?
I have too.
Oh.
I just don't own a car. There's a difference between those two things.
What I filed was a motion to dismiss, special appearance, criminal complaint, challenge to subject matter jurisdiction, and a counterclaim, and a information request about officer. It was the county. I think they only have one police there. They only have one red light. So
you're counting cops by the number of red lights the town has?
Well, I think it was the only one that when I remember seeing it on the website, there was only one. There's like one person that works in the court and one judge and then one cop, something like that. So it was 2021. So really, I'll call tomorrow and get a copy of what's in the record.
And what are we looking for when we get the record?
Well, we're looking to see what they filed and what they have in the record and what I put in the record. Probably more important what they put in the record.
And
the adjudicatory
are
record.
we looking for when we look at what they've got in the record?
A complaint.
And what else?
A citation.
And what else?
A notice of a hearing, maybe. No, they're not going to have that because
they should have if they actually sent you a notice to appear for anything.
It's on the ticket. It's on the ticket.
Again, Jane, if they sent you anything, even if there's an outstanding warrant, okay?
Yeah.
But the question is okay, here's their problem, depending upon what's in the court file. If the only thing in the court file is the citation, then they have a problem if they issued a warrant because there's no complaint accompanying the citation and you didn't waive the filing of a complaint.
No.
Okay, so what did they base the warrant on?
If they have a warrant.
Well, the citation, see, that's where Texas law doesn't say anything about them being able to base a warrant on a citation. Texas law very clearly says that the warrant can only be issued once a complaint's been filed, unless it's a verbal order to arrest by a magistrate.
I don't think they have an order to arrest. They're just trying to collect the money without letting me.
A warrant would be an order to arrest, Jane.
I understand that. I'm saying that all I got that made me aware of this was the thing from the attorneys trying to collect the money. That's it. Collection agency.
Okay, and what does that have to do with what we're talking about? How you found out about it is fucking irrelevant, Jane.
I'm just saying that there's not a warrant.
You don't know that, Jane.
It won't know until I call, but if there is a warrant, you already just got through saying if there's not a complaint, then there can't be a warrant.
No, I didn't say that, Jane. I said there can't be a legitimate warrant if there's not a complaint. But I did not say there couldn't be a warrant.
Okay.
If they issued a warrant without a signed complaint, then that's, according to Texas procedure, an invalid warrant. That's problem number one for them.
James, deja vu from the Beaumont court. They did the exact same crap to me, and we had their crap dismissed with Eddie's motion.
Well, you live right down there by there, and I don't live anywhere. I don't think
That's not the point she's making, Jane.
I understand. I understand. What I'm saying is, this people, I mean, if they did issue a warrant, would it be like statewide?
Probably not. Otherwise, every time you've gotten a ticket every other time, you'd have gotten arrested on it, wouldn't you?
No, I hadn't gotten no ticket since then.
You got the speeding ticket.
Well, okay,
that
yeah.
we fought. So if there'd have been a statewide warrant, that would have come up when they ran your license, wouldn't it?
Well, I think they just now thought about it after the fact. Hey,
Well, if they issue it now, Jane, they're way past their statute of limitations. So the warrant wouldn't be any good.
Good.
So the other problem here is if they haven't issued the warrant until now or whatever, they're past their statute of limitations. They're screwed there. If they haven't filed a complaint in all this time, then it's failure to prosecute. Filing it now and then trying to issue a warrant on it would also not fly, because that's a direct violation of Chapter 45A, where they must be within the statute of limitations to even file the complaint. And if they have filed a complaint, but they never issued a warrant, then the statute of limitations never stopped running. And at 2 years, they're dead in the water.
So what if they did file a complaint and it's been sitting there all this time?
I just answered that question.
Okay. So it's
If
dead
they
in the water.
filed a complaint but did not file a warrant, too bad for them. They only had 2 years to prosecute it. So the same thing applies if they just filed the citation and never issued a warrant. They only have 2 years from the date of the offense to file the complaint and to prosecute the case.
Yes.
So if all they did was put in the citation and never file a complaint, they're dead in the water. If all they did was put in the citation and file a complaint but no warrant, they're dead in the water. But if they did file the citation and they did file a complaint and they did file a warrant, within the 2 years, that's a different animal. Now they're covered. Statute of limitations got told, and now you've got to go down and turn yourself in to get off the warrant.
Shit. Fat chance. I mean, I go down there to tell, show them that they
But
can't.
here's the other problem. You're not required, they could not issue a warrant for failure to appear based solely on the citation.
Exactly.
The law has been changed on that since 2017. In 2017, they changed the statute to say they can no longer issue warrants based on failure to appear for a citation alone. There must have been a communication from the court, and you failed to comply with that notice from the court. So this is why we have to see what's in the court record. If they sent something out, what address did they send it to if you're claiming you never got it? And if they didn't send it certified mail return receipt requested, they can't prove you ever did get it. And no matter how they write the statute, what they cannot do is write a statute that says notice is not required. So when they say, if they say they mailed it, it doesn't, then they don't have to prove that you got it. And that's bullshit. They absolutely do have to prove that you got it.
But it doesn't say that in the statute, right?
The statute says they don't have to prove it if all they do is say they mailed it. But that is a direct violation of due process because it violates the right of notice.
Right.
Yes, Kevin.
So in my case, they never ever sent the complaint before.
Wait, say that again?
They never sent the complaint in my case.
They don't have to send you the complaint. They just have to send you a notice to appear in the court.
They don't need a complaint?
They have to have a complaint to prosecute you and to move forward with the case.
They never
if they're
had a
moving
complaint.
forward without a complaint, then they have a big problem. They're taking steps outside of the statute of limitations.
During trial, we made an objection to the complaint because we were never served with it. The judge told the prosecutor to serve the complaint in the middle of trial.
In the middle of the trial?
Yes.
No, they can only sub it before the trial starts. Once the trial starts, they can't change the fucking complaint.
Well, my dad made an objection to that, and the judge just said move on.
Well, then he damn well needs to appeal it because they cannot change it after the prosecution's commenced.
We already appealed it already.
Okay? They
But
they cannot change the complaint in the middle of the fucking trial.
But what do you do if they say move on or something like that?
No, Judge, I want a ruling on my objection. I don't want to move on. I want a sustained or denied or overruled. Give me something I can put in on appeal.
My dad said to make an exception, but the judge said denied for that.
You don't have to make an exception. When you object to it, the exception is already made. That's the reason for an objection.
Okay.
What you want is the judge to make a proper ruling.
He did not. He only said move on. That's it.
No, Judge, objection. I either want a sustained or an overruled. I want a proper ruling on my objection that I can appeal.
Okay, thank you.
Come on. What else y'all got?
The motions that we filed, for Irving, the motion to quash, there's like 4 or 5 different versions of it. From the first one started in
No,
422.
there's 4 or 5 iterations of it every time they've changed the complaint.
But the ones that we initially filed from April, I think it was April, which was totally changed after that. Does that still have to? That's something I have to keep track with, or keep in the file, or whatever.
Yes, Jane, you keep every fucking thing that goes into this court case. Everything.
Okay.
Why would you think you don't have to keep copies of everything you file?
I've got it, but just didn't want to put it in because it's so heavy. I mean, everything is so lengthy that I didn't want to have that one being the thing that I carried around. But I put 2 motions.
Well, if you have to make reference to it, Jane, what are you going to do if you don't have it? If you go to court and the court asks, well, you filed this on this day, and you have nothing to verify that what he's saying you is accurate.
Oh, I've got it.
Because you don't have anything to look at because you left it at home because it was heavy.
No, I got it in. I got it.
Either get something with wheels on it or stop getting fucking tickets. That's pretty much your option. Why do you think lawyers roll into courtrooms with a rolling bag instead of carrying shit?
No, it's ridiculous how much paperwork it takes.
Yeah, exactly. But it does take it.
Get your dates figured out.
For what dates?
The dates you thought you missed in filing or something that about the email.
Oh
you
yeah,
emailed.
the 10 days. I think it's 10 days, or I think it's 7 days. But I still right now it's what I have to look at the calendar. It's the 16th is when my court is. I think I still have time.
What
Okay,
is
'cause
the purpose of the 16th?
The purpose is pre-trial, but it could be trial also.
And what are they saying they're going to do at pretrial?
Well, they're not saying anything. They just said that's when I need to show up. I asked for a motions hearing for the motion hearing. Remember, I scheduled a motion hearing, and that was she
For the
told me.
16th?
Yeah.
Okay.
And then they got back with me and said, could I come in like a couple weeks ago or about a month ago instead? And I said, no, I can't, because they told me this is the only date they had until through October. And she said, well, I thought maybe you might want to present your motion. And I said, well, I am on the 16th. So I don't know. If it's like the other judge, he'll go right into the trial unless he dismisses it.
Well, I guess we'll see.
Yep. So I have, let's see.
But whether they dismiss it or not, Jane, you
I'm
need
still
to
going
go
after
in there calm and prepared to do
Oh, yeah.
what we've talked about.
Oh, yeah.
I love this. She says, oh, yeah. And every time she says, oh, yeah, in that style, who
You don't
wants to
know.
guess what's going through my head?
You don't even know.
Unfortunately,
no.
Jane, that's not exactly accurate either, is it?
Well, the last time I went to trial in Irving, you weren't anywhere around. And I freaking, that's when I first got in your class. And I dive bombed on that. But so
And yet we did a shit ton of prep to get you ready for that. And you still dive bombed.
no, we didn't. I just got in your class then. We didn't get to a shit ton. It was when you were moving from Austin up here to Plano and your brother was sick and all that. So
What
we
year
didn't-
was that?
that was in 2000 and let's see. I got the cat trap charges in 2019.
I got here in 2022.
Okay, so it was in 2021 then. But I went to trial, but you didn't start class right away, did you? Because I remember
No,
that
I didn't.
yeah, my trial was in July the 14th, and I had not talked to you at all since you had you moved or whatever.
Well, then what is the benefit of you bitching that I was nowhere around?
Well, you weren't
You
because
didn't
I
even talk to me. Then how in the hell was I
how am I
supposed to?
supposed to talk to you? I don't have any way of contacting you. If I email and you don't respond, then what else am I going to do? Hunt you down? I probably couldn't find you since you're off the grid.
Just ask Chat that
Chat GPT?
Yeah, I bet the chat thing knows.
So what else does somebody have?
I have a question. I have a question about, quite frankly, it has nothing to do with any of this, but license plates. What would you put on a private vehicle for license plates, Eddie?
Private, not for hire.
Okay. That's what I'll do.
Shit, you're gonna get in trouble too. I wouldn't go by what he says about that.
Well,
I'm not
tell
worried about
anybody to
that.
go do it. They asked me what I would do with it, and that's what was on my car.
Right.
I had that on my car for years.
And what'd they do?
Left me alone.
Mm.
Hell, I had cops in Nacogdoches follow me all over the place, but they wouldn't pull me over.
Yeah, well, they knew who you were because you used to be one of them.
No, not these guys. They didn't.
Oh,
I hadn't been one of them since 1990 or 91.
oh,
I even drove around Austin like that.
Yeah, I don't think New England is as forgiving as
I don't think so either.
Well,
some of the other states
the
are.
difference is I know what the laws are here, and I can
Right.
argue them with anybody, toe to toe and better. If you
Right.
can't do that wherever you are, then I recommend you don't do that where you are.
Yeah.
Okay.
The simple fact of the matter is, do not pick a fight you can't win because you're not prepared and trained for it. And this class
makes
by
sense.
itself does not make you trained for it. This class will tell you how to go to court, but it doesn't tell you what the law in the given state is that you're in. I can tell you what
Right.
Texas law is at the drop of a hat.
Right.
I can tell you that Arkansas law is pretty much the same as Texas law, though it's written different. It still comes from the same place. And Arkansas law specifically says it's relating only to carriers and commercial use of the roads. It says it right in the statutes that nobody in
Maine-
Arkansas apparently reads.
Maine does not say it in the stat. Maine has tried to violate the single subject rule. They've tried to add private in
No,
with
guaranteed they
public.
didn't. I guarantee you they didn't. The law says exactly what it should say. Their interpretation of it is what's off,
Okay.
because that's exactly what they do here. The law says exactly what it's supposed to say and how it's supposed to say it. What is wrong
does-
is how they're reading it and applying it.
Now it doesn't here. They actually it did before. It was either January of this year or last year. They repealed the code and redid it. And it's completely different from what it said originally, which did and actually had a specific thing that said, hey, not everybody may be needing this. But that's all wiped out, and now it specifically mixes public and private. I have both iterations of it, so
Okay, well, then you might have a constitutional challenge case there.
yeah, I'm sure there is, because there's no doubt that it's unlawful. They did. I don't remember the exact title you told me of the federal code, but they did base their transportation code on that. Was it Title 49 or something like that?
Yeah, Title 49 United States Code and and Code of Federal Regulations.
It is based on Title 49, the main transportation code. So that I was able to find. You gave me those breadcrumbs a little while ago, and I did follow those. I know not having a registration here is not criminal, but not having a license is. But I've never had a Maine license. I moved up here from Massachusetts. I've got maybe a year left on my Massachusetts license, and I'm just going to let it expire. But I've never had a license in the state of Maine.
Hey, Eddie.
Yes.
On our discussion earlier on the public records request, I want to share in the chat the paperwork that I got to give you a better idea on why I thought that they have some files. Here's one.
Oh, yeah, I'm going to write one more motion for sanctions for the discovery violation.
That was the wrong one, Eddie. Hold on. Sorry. Okay. These two records that I just put in the chat. On the one, it says no records exist that are responsive to your request. And then on the other officer, it gives me the code, and then it has a paragraph explanation on it. I think that if there was no records that actually existed as far as what they're saying here, then they would just put what they put on the first officers.
And you said it's only the last two?
Yeah, the last two, sorry.
Now, did you give them to me in order?
The second, the first photo I sent, ignore that one. But the next two I sent were, the first one was one officer, and then the second one was the second officer.
Okay. What records are protected in an officer's personnel file?
I guess all the ones that they deem are.
Nope. Did you read this?
Yeah.
Your
What was-
request, internal affairs investigation records, response pursuant to IC 5-14-3-4B8, personnel files of public employees and files of applicants for public employment may be maintained as confidential with narrow exceptions. To the
Okay.
extent you are requesting copies of all internal affairs investigation records from the personnel file of Officer McKee, such records are permitted to be maintained as confidential. So what you did was you asked for a blanket all.
Okay.
Therefore, since they don't know exactly what you want, they don't know exactly what parts are accepted.
Gotcha.
Therefore, you need to narrowly tailor your request by reading this statute to see what they must give you versus what they cannot give you,
Right.
and ask only for what they can.
Well, the statute, they pretty much use the definition of it in the next response that they only can release the factual basis for a disciplinary action in which a final action has been taken. And those are the only kind of records that they can release.
Okay, they gave you an attached lawsuit filed against Officer McKee, right?
Correct.
Okay. Disciplinary actions or findings, suspensions, reprimands, demotions, terminations. The Indiana access to public records only requires the release of the factual basis for a disciplinary action in which final action has been taken, and that resulted in the employee being suspended, demoted, or discharged. Okay. All other disciplinary records are permitted to be exempted from disclosure pursuant to no disciplinary records exist that are subject to mandatory disclosure. Therefore, your request is denied. So again, public information disclosure versus discovery disclosure. Two different animals.
So would the prosecutor not be allowed to disclose to me what they're referring to here?
If you did it in a public information request, yes, because the law says they don't have to give it to you as part of public information requests.
Right.
However, if you filed it in a motion for discovery, that's not a public information request. That's information related to a lawsuit that they cannot withhold without judicial approval.
Right. Well, in Indiana, it's mandatory that they hand it over automatically, unless I know that there's some records that they're withholding. Then I can file a motion to
Which
compel.
you are going to prove how. How do you prove they're withholding records?
I don't know.
Well, there's your problem. You're making an assertion that you know they're withholding, but yet you can't tell me how you're going to prove that they're withholding or exactly what they're withholding. Right? Because you don't know.
Right.
All right. So how are you going to prove to a judge they're withholding so that he forces them to produce it and sanctions them if they don't, especially when they're telling you there ain't no such record?
Well, I guess I was just judging by what they were saying on the other officers under the same.
Well, again, I
exact
showed you
thing,
exactly
if
how
that
that
was-
could work. I showed you
Right.
why that's not a good argument.
Right.
There's always the first rule. Can you prove it?
Right.
If you can't, then it's guess or it's an opinion, but
Right.
it's not a fact. And facts are the only things the court will work with.
So how could I prove this? Could I just file another records request and ask them if there is even investigation records? That's like a yes or no.
Well, what records are accepted that they have to disclose? Right here, it tells you that there are narrow exceptions for the types of records that they must give you.
Right.
Versus the ones they are allowed not to give you. So what are the narrow exceptions? And then the inference can be made. Well, if the narrow exceptions includes this record and I got this record, then that means there has to be this record in there as well because they can't file this one without that one. Now that would be proof that there's a record that exists they're not giving you. Never ask for an information request so broad that they can deny it out of hand by going, well, you asked for everything, and since there's certain things I can't give you by law, then I don't know what you're asking for, and I can just say, sorry, can't give it to you.
Right. Well, I guess I made it broad because I wasn't really sure exactly what they were allowed to give me at the
Well,
time
you
that I
need to go
filed
look
the
up that
request.
statute and see, because that statute's what they're referencing. That's where you're going to find it.
Yeah. Okay.
Now read the whole thing, not just the section they pointed you at, B8.
Yeah.
Okay. And see if there's exceptions in other parts of that statute for other things that they may not want to give you, but must.
Okay.
And ask specifically for those things.
Gotcha. Thank you.
Mm-hmm.
But,
Are we on open topics tonight?
yeah, you got
Yeah,
something?
go
Looks that
ahead.
way.
I've got a couple speeding citations. I'm
Oh,
trying to
no.
learn what you're doing, Eddie, and well, I'm trying to put into practice what you and Brett and Randy have done.
In what state?
Texas, Bexar County to be exact.
Okay.
So I've got a municipal one. I filed a bunch of motions arguing that charging instrument alone, it does not provide them subject matter jurisdiction. So I challenged that. I challenged no jurisdiction based on
Hold
that.
up. Stop. What are you calling a charging instrument?
What they're claiming is a charging instrument, which is a complaint. It is neither a information or an indictment.
Right.
So I challenged subject matter jurisdiction on that, challenged jurisdiction of the court in general on the basis that the officer is not
Well,
even
you have
allowed
to
to
challenge the
force.
statute allowing them to use the complaint alone without an indictment or information, because that's unconstitutional. See, the thing is you're going into a bunch of stuff that requires a lot of parts to make the argument. One of those parts is the original court case that made that determination, which was a direct violation of both the state constitution and state law on the subject of what a charging instrument is. What they did was a bass-backwards analysis of the statute. They said that because the legislature authorized the city attorney to prosecute, that meant they didn't have to file an information. The problem is the state constitution says that's the only thing that gives the court jurisdiction is an indictment or information. Doesn't say a damn thing about a complaint.
Right. Article 1, Section 10.
Not to mention
Or
the
Article
fact
5.
Not to mention the fact that the legislature has no constitutional authority to delegate a power of the executive branch to a city attorney. The state constitution only empowers county and district attorneys to prosecute in the name of the state as attorneys for the state, not city attorneys. The Constitution gives the legislature the power to create new types of courts, but it does not give them the power to create new types of prosecutors.
Right.
But nobody's challenging them on that. But
Nor are
Well-
they allowed to delegate a constitutional power to someone else, especially when it belongs to a completely different department than theirs.
Okay. So subject matter jurisdiction challenge, I specifically cited Article 5. I think it's Article 5, Section 10 or 12. I forget. I got it right in my briefing as I quoted the state constitution. So I cited that. I did not cite the court case, but I believe I
Relative
made
to
enough
what?
of a
The
case.
charging instrument?
Yes, relative to their complaint. They solely have a
That's-
complaint.
Okay, that's Article 5, Section 12 or 21. I'm pretty sure it's 12.
Yeah.
Article 5, Section 12 says that an indictment or information invests the court with jurisdiction of the cause.
Yep.
Complaint
Last sentence of that
cannot fucking
paragraph.
do it. Okay?
Right.
yeah, but there's tons of case law. There's tons of opinions that say that complaint.
I
needs-
know that, Jane,
I'm
but they're
telling you.
based upon the original case I'm talking about that completely violated the state constitution and state law.
I'm not saying that they don't. They're not.
Okay. So that's why you have to go back to that case and show that that case was decided in error. Thus, every case that cited it since was also decided in error. It is the judiciary attempting to invalidate and render of no consequence a specific provision of the Texas Constitution, and they cannot fucking do it.
Yeah.
They are trying to render Article 5, Section 12, the last clause of that section, superfluous and of no effect. That's exactly what they tried to do with that court ruling. And that's exactly why the ruling is unconstitutional. And why every ruling based on it is equally unconstitutional.
Yeah, I don't think we ever found out exactly what that case was.
Yes, I have the case. I told you I have the case. I
I
just had
know,
to go
but
back and find it.
I know we were looking for it one night. And I don't think we ever found it.
Well, we didn't find it while we were looking for it then, but it's there.
Well, I
It's
think
in Randy's lawsuit.
so.
So Eddie, I get what you're saying, that you're suggesting arguing the original case that decided that erroneously. Now, I didn't go to that extent in my pleadings, but I did make it clear that there's nothing that provides nothing invests a court with jurisdiction based on complaint alone. And I cited the Texas Constitution, Article 5, Section 12.
You're right, but that's how they're going to counter what you said. I guarantee you, if there is a response from either the court or the prosecution, they're going to argue the original case in every case based upon its sense.
Right.
Okay? So you have to show why the original case was in direct violation of the state constitution and did a constitutionally forbidden act, which is to render that clause of the Constitution null and of no effect. Null, void, and no effect, and superfluous. They can't do that. And there's tons of court opinions that say they can't do that. Their own opinions that say they can't do that. They cannot read a provision of the Constitution in a way that invalidates it or renders it void or renders it superfluous and of no effect. Their own case law says that. So when that court originally decided they didn't have to follow the Constitution as to what gave a court jurisdiction, because a statute that is unconstitutional on its face gave a power to a city attorney the legislature cannot also legitimately give them, then you've got multiple constitutional violations. Not just one, multiple. That's why you have to go back to the original case. It's not a one violation argument. It is a multiple compound violation argument.
Okay.
I'm going to give you put a little bug in your ear about one thing you cannot do when you're fighting with these courts about their opinions. You know how a rat can crawl through the tiniest crack and hole that you leave behind to escape any trap or any way you try to trap it in?
Yep.
Well, that's exactly what the fuck you're looking at with these courts. They're the rat, and they will find any crack in what you try to pin them in with to escape. So don't give them one.
Okay.
Either cut off all the exits or don't fucking bother.
Yeah, and he's got like 70-page motions with this argument or more, you know.
Who does, Jane?
I do.
Eddie does.
Those happen to be on your public folder by any chance?
No,
Eddie?
they're in the seminar material.
Okay.
Well, actually, that one's not. The city attorney one's not.
Okay.
Yeah.
But the complaint one is.
For the city attorney, I've gone through the sections of the several sections of the Code of Criminal Procedure that talk about the phrase attorney representing the state.
No, it's attorney for the state.
In the name of the state.
Well, the citation I've copied and pasted directly from the Code of Criminal Procedure that refers to that.
Yeah.
And I wrote up criminal complaints on all the city attorneys, all the city attorneys that took part in the case, and backed that up with records requests to the county and the municipality asking for their oaths of office, and they have none.
Well, of course they don't, because they're appointed.
They're appointed.
Again, they're appointed by the city manager and the mayor.
Correct.
They're hired right off the fucking street, like out of any law firm they want to contract with. They're private attorneys or they're direct employees of the city.
Yeah. So I've alleged that they don't have a bond or an oath of office the way a county attorney or DA would have.
They're also not elected.
Correct.
That's another problem. That's exactly why the Constitution only allows county and district attorneys to prosecute, because they are the only ones accountable to the people of Texas for what they do in that position.
Right. So I've done motions for sanctions against them. I've got criminal complaints against them on file. I've tried to disqualify the judge for 3903 violations with due process. And the first citation I've got, none of that worked. Of course, they ruled against me, and I've got an appeal on file with the county court.
Well, they're going to keep ruling against you till you cut off all the exits.
Well, with a county appeal, if I didn't properly cover all of the ways for them to argue that complaint only as a charging instrument, is there a way to address that, or do I have to handle that in the next level of appeal?
Let me show you something here. You can't handle anything extra on appeal. The only thing you can handle on appeal is what was heard at trial. You don't get to submit new evidence on an appeal.
Is it a court of record?
I believe it is. They don't say court of record on the front of the building, but I've looked it up, and it does say it is supposed to be a municipal court of record.
So it's going to be on the errors on the.
Okay. Do y'all see this screen right here?
Yeah.
Okay. That's how many different sections of different codes the term attorney for the state actually appears. But within each one of these, there are multiple entries for it. Let me give you an example. In the Bill of Rights, the legislature may enact laws to provide that a judge, attorney for the state, peace officer, blah, blah, blah. There's only one entry for that in the Bill of Rights. However, information written is represented to a court by an attorney for the state. That goes hand in hand with right here. Let's see. Yeah, the attorney for the state is the what the attorneys in section 21 of Article 5, which are the county and district attorneys. County attorneys, district attorneys. That is your attorneys for the state. Okay. So when it talks about it up here in section 12, that's what it's talking about. A court by an attorney for the state. Okay. Then you get into the actual statutes. And I've got a motion that covered, the city attorney motion covers all of these. Every single statute that's got it in it, I've got an entry for in there. Okay. So the thing about it is not once, anywhere in all of these references to attorney for the state, not one single time is the city attorney ever part of that list. Not once. And then when you go to the new chapter 45A, okay, which for some reason isn't coming up here and it should.
It's attorney representing the state.
And
I believe. If you look at, I posted in the chat, Eddie, a link to chapter 2A, section 2A.101. That's one of my points of reference in the update, the revised chapter 2, the Code of Criminal Procedure. But that rule right there, 2A.101, is one of the points of reference I use. That doesn't call in municipal attorneys. I believe it's 45A, like you were saying, but they make that new title. And they include, I don't know exactly where it is off the top of my head, but there's a reference where they include or allow supposedly inclusion of municipal attorneys to be part of that list.
No, that's 45A, not 2A.
No, 2A also, well, yeah, 45A is where the expansion of it is, and 2A.101 is where they're using attorney representing the state as opposed to attorney for the state.
A marshal, a member of an arson investigation, a municipal park and recreation patrol officer.
I can't tell what that window is that you're looking at right there. What is that? What chapter?
This is 2A.
2A.
There is nothing in here that says municipal attorney.
Okay, so hold on. Go look up 45A, 45A.005. Oh,
I know. 45A used to be 45.201.
Yep.
Okay, and that's the only one that says anything, but it tells you right there that the term attorney for the state does not include a municipal attorney.
Where are you seeing that at? 45A.005 is what they rely on to claim a municipal attorney can conduct prosecutions.
It's what they use to authorize a municipal attorney.
Right.
Okay, but
that's where they're misusing it. They're trying to say they're allowed to prosecute, and I believe that's only intended to include city ordinances, not representing the state, which is what they're contorting it into.
Yeah, but too bad that like speeding tickets are criminal. feeding your cat.
Eddie, have you ever gone so far as to try to use grand juries the way that Randy has been talking about a lot lately?
I've used them before, but I don't use them the way Randy talks about. Randy thinks this is a political thing. It's not.
So I want to short circuit. I want to get this speeding citation dismissed for the reasons that they're not following the Constitution or the statutory due process. Have I already shot myself in the foot based on what I've told you so far?
You haven't shot yourself in the foot, but you haven't done yourself any favors either, because you haven't covered all the bases. You've left them wiggle room, and they will use it.
You got a good write-up I can reference that takes care of the wiggle room you're referring to?
Well, it has to be already on the record, though.
Like I said, you can't use it now.
Okay.
If you didn't submit it at trial or make it at trial, then it's not going to, you can't use it on appeal. Of
I got 2 more questions after y'all get them.
course you do.
Of course I do. Well, one of them is just, I want to ask you, I have a list of cases. I want to ask you if they would trigger your memory on the original one.
Did they do any recent amendments to this?
Oh, wow.
Because I know for damn certain it said right here in this chapter that the city attorney is not an attorney for the state.
In chapter 45?
Yeah.
I thought it said that too. Let's see.
In fact, let me look at in one of y'all's motions that I've done for y'all, it's in there, the exact statement.
Was it the one? Well, no, I don't think we argued that.
I'm wondering if it's in Helen's.
It might be Helen's, yeah. What about 45A005? You already went over that? Okay. It says a municipal attorney or deputy municipal attorney shall conduct each prosecution in municipal court.
I have that statute somewhere.
What did you say that phrase was again?
Attorney for the state.
What are you looking for exactly?
I'm looking for the specific statute that says that the city attorney is not an attorney for the state.
There's so 2A101 is not it?
2A101.
Yeah. No, it's actually, that's kind of repetitive what the other one says. And okay, attorney representing the state, including a special prosecutor, may not suppress fact. Okay, that's not. But also the primary duty of the attorney. No, that's not it.
There we go.
Where?
2A209, subitem 1. Attorney representing the state means an attorney authorized by law to represent the state in a criminal case, including a district attorney, criminal district attorney, or county attorney with criminal jurisdiction. The term does not include an attorney representing the state in a justice or municipal court under Chapter 45.
So it's 2A209. Okay.
Subitem or 2A.209A1.
But that only refers to chapter 45, not the newly released 45A.
It doesn't matter. It doesn't matter. The fact that they renumbered it to 45A does not change the Constitution in any way, shape, or form, or who is actually an attorney for the state. And it damn sure is not a municipal attorney.
So then it's still a good argument to make, even though it says 45.
Yes, it's still a good argument to make. It's
how
still
does it-
unconstitutional no matter how they slice it. When
Yeah.
they try to give the power to prosecute to a municipal attorney, it's a violation of the state constitution. But like I say, it goes into multiple pieces. This is why you can't take one thing and use it. You've got to use them all. Okay? Let's look at how it's structured in the Code of Criminal Procedure. If we take the Constitution under Article 5, Section 12, last clause, an indictment or information invests the court with jurisdiction of the cause. Who can sign an indictment or an information?
District, county.
County attorney, district attorney.
Correct. They're the only ones that can sign an information, right?
Right.
And they must do so in their official capacity, right?
Right.
And that information or an indictment are the only two things, according to the Constitution, that invest the court with jurisdiction of the cause,
Right.
right?
That's what it says.
All right. Article 5, Section 21 specifically says the power to prosecute in the name of the state is given only to two elected offices, the county and district attorney. The city attorney is not employed by, is not supervised by, is not regulated by, and does not have oversight by any part of the county or district attorney's office in any way, shape, or form. They are nowhere near associated with either of those offices.
Nope.
They are private hired guns or direct employee hired guns. They're either contracted from a private firm or they're directly employed by the municipality. You got it? They do
Right.
not and are not in any way, shape, or form a part of the county or district attorney's office. Therefore, they have no prosecutorial immunity when they fuck up. That means prosecuting somebody illegally puts that city attorney directly in the crosshairs of a fucking lawsuit. And he does not have prosecutorial immunity to hide behind because the state constitution says he is not and cannot ever be a prosecuting attorney for the state. Okay. That's a little caveat none of them seem to think about. But what they've done is they've drawn a bullseye on the forehead of every fucking city attorney that steps into that courtroom and tries to act as a fucking prosecutor for the state.
Well, you're preaching to the choir. I get you. I like the way that 21 breaks it down. I haven't got to read it through it yet. I get your summarization of it.
Well, that's not all of it. There's more.
There's
Okay.
a
Okay.
yeah.
45.201 is what they originally used to say that the city attorney could prosecute in municipal courts in the name of the state. And the whole reason they said that that statute was valid was because the legislature wrote a statute saying since the city attorney was the one to do the prosecuting, then, and they can't sign an indictment or an information, then an indictment or information isn't required to invest the court with jurisdiction. It can only be the complaint. And that's how they got away with doing it, by complaint alone. Okay. So you've got to yank that step out from under them as well. You've got to connect those dots. They're going at it completely ass backwards. The statute cannot override the Constitution. Therefore, the original case saying that because the statute says this, the Constitution don't mean shit is completely wrong.
Was that Greenwood or Vallejo? Vallejo.
Greenwood was one of them. I don't know if it was the first one or if it was one of the subsequent ones based on the first one.
That was 1957. Then there's Vallejo, 1966. Then there was Bass. Does that sound familiar?
It's in Randy's lawsuit. It's down toward the very end of Randy's lawsuit.
I thought that Julie searched for it and couldn't find it. Then there's Bell, Bozeman, Kindly.
Well, like I say, there's all kinds of them that have referenced it, and every damn one of them is wrong because the original case was wrong.
Q. Yeah.
Okay. But because no indictment or information is being filed, no jurisdiction is ever vested in the court. The statute cannot override the Constitution to give a court jurisdiction where the Constitution says they cannot have it. So that's another hole to plug. Yeah, I've got, in fact, I'm wondering, Julie, do you remember whether or not it's in the book, the new book? Right? Don't I talk about the city attorney in the new book?
Yes.
All right, let me see.
Is it that
All right, yeah.
Michelle?
The corporate or
Michelle?
municipal attorney, the worm in the constitutional apple. All right, so this is out of the new book. And I go into everything I've talked about so far. The city attorney does not work for the county attorney in any way, shape, or form. The Texas legislature has directly violated the Texas Constitution in 45A.005, which was formerly 45.201. And we have a specific court case on this, by the way, that says that the power to prosecute in the name of the state is a constitutionally delegated power. All right, prosecutor power of the state is one specifically delegated by the Texas Constitution to only two elected offices and officers, the county and district attorney's office and the individual duly elected or appointed to hold that office. As such, this power and authority may not be redelegated, appointed, apportioned, or assigned to any other person or office by a statutory enactment of the legislature or by the courts via non-authoritative local rules of procedure.
Is that your completed book or is it still a work in progress?
It's still a work in progress. And here it goes into the section where it says the legislature may create courts by statutes, not prosecutors. I've got the actual court case for that. I've actually got that in its own little folder, so I know where to find it.
So if I've raised the issue, but I did not address the court case in the any motions in the pretrial or in the actual trial itself. I don't believe they got on the record a response that cited any court case. They just shut me down, and the judge did not. She denied my motion, and my motion was a motion to dismiss for lack of subject matter jurisdiction. Now, does that mean that in the appeal process, I'm going to have an opportunity to say, well, my point is correct. You should look at this case that I did not cite in my appeal?
No.
Does it work that way?
No, it does not. You cannot introduce any new evidence or information on appeal. Okay. The only way you could do that is if the evidence was withheld for some reason when it should have been provided, or it's newly discovered evidence. But if it was stuff that was known and available at the time of trial and you didn't get it in, it's not getting in now.
Okay. So is there any writing to that ship of getting that conviction dismissed or reversed?
No.
No. Hang on just a second.
What did it cost you to appeal?
So far, it's cost me nothing. I had an affidavit of inability to pay that was not ruled on or contested.
Oh, wow. Okay.
Well, that was easy. I just filed that. I had it notarized, had it filed, and they don't bother to read any motions.
Yeah, they are supposed to have a hearing on it, which they would have denied it anyway, but.
Well, they never look at their own paperwork, and that's their own darn fault.
Right. But you're supposed to request a hearing on those things,
Well, during the trial on the merits, I
Yeah.
raised it and asked her to rule on it.
Yeah.
She said the judge said she would take it under consideration and never mention it again. Didn't allow it, didn't deny it, nothing.
When did you file the inability to pay? Was it right before right at the same time you filed for the appeal?
Oh, I filed it months in advance of that.
Okay, that's what I should have done. I guess I could still do that because it's going to cost me like $2,000 to appeal my latest one. Actually, I probably should go ahead and file that.
Well, I thought I knew right where it was
You got a release date for that book yet, Eddie?
when it's done.
I've got the traffic seminar that Eddie and Randy and Deborah did a while back, but because there's been legislation changes, it's getting long in the tooth.
What county did you say you're in?
Bear.
Oh, Bear. Oh, Bear County. I'm trying to think of where that's at.
San Antonio.
Oh, yeah, that's right. That's right.
I know I have that daggum case.
I'm gonna put it in the chat.
Uh-oh, somebody else in here got a question too. Donna.
Jules, what is that lawsuit from Randy? Which one specifically are you referring to?
No, I have it labeled. I have it
thought
somewhere.
I had it labeled too. I specifically thought I had in the file name.
So Jules, I'm looking in that state v. Moore. What, and I'm trying to remember what the phrase is. This covers that a municipal attorney may not be a prosecutor for the state of Texas. Is that right?
I'm not that familiar with it, but I thought it had something to do with just recognizing the constitutional protections of the county and district attorneys, their authority to prosecute is what I understand. But I could be wrong. Again, that may not even be the case that Eddie had in mind.
It's only 14 pages. I'll read through it and figure it out. Thank you. Is this the appellate brief where Randy and Carabelle were in the
That was a lawsuit, yeah.
Okay, I'm gonna send it.
Did you see Donna's question in the chat, right, Eddie?
Nope, I'm not looking at the chat.
Oh,
You have, Donna.
she put in the chat. Let's see. About a lien.
Well, I got the idea that they put it in the chat. You said that already. What I need to know is, since I'm not looking at the chat, is what's the question?
Donna, are you there? Donna. I'll tell you what it says, so in case you want it. Oh, there she is. Can't hear you though. Donna. Go
Hey,
ahead,
Eddie.
Donna. Oh, good.
I've got a property that a city put a lien on the house for cutting 2 trees, and they didn't give me notice. This was back in 2015. So I was fighting it, and they never would respond. They quit responding, blah blah blah. And so back in 2022, I was selling the property. Got it under contract, and they had the lien still on there. It's a $6,800 lien. So the closing attorney tried to contact them to get it straightened out. They they wouldn't respond to it, or they denied knowing anything about it. So I ended up losing the contract, and about 4 months later, they had a city council meeting and said that that they are removing the lien due to not following the rules. So they created a resolution. That was in August of 2022. So the city attorney said that he would email me a copy once it's recorded in the probate. So they never did send anything to me. So in 2025, March of 2025, I had a closing attorney to do a title search, and the lien was still on there. So the end of April, they finally took that resolution that they created in 2022 and filed it immediately after I threatened to file a Title 42 lawsuit.
Yeah.
So I was wanting to know if once I get it typed up, if you will look over it and pick it to make sure it's pretty tight.
I can look at it. What state are you in?
Alabama.
Okay, well, I don't know Alabama law, so I don't know what they can and can't do, but I can look at it and try.
Well, the lien was put on the property unlawfully. They didn't give me any kind of notice and opportunity. And so they admitted it in a video on the city council meeting. So with them admitting in the video, and then they created the resolution to remove the lien, and then them filing the resolution, that's an admission of guilt.
Well, yeah, but the question is what's your statute of limitations on this?
Well, since they just removed it, it's been ongoing. So I have 6 months from the time that they removed the lien to send them a claim form. And then I will have 6 years for trespass of rights when I file the Title 42. But I'm filing it in the next couple of months. I'm going to send them a claim form first.
Okay. Yeah, you can send it to me. I'll see what I can figure out about it.
Okay, because I think it's going to be pretty much an open and shut case with them admitting that they unlawfully put the lien on it. And it's been, this November will be almost 10 years that they had the lien on the property. I think it ended up being 9 years and I think 3 or 4 months, 5 months, something like that.
Yeah, pardon me. I'm trying to look through this motion I started back in 2022 on a rewrite for the city attorney. And I'm trying to see if I got that case in it.
Well, I think I'm gonna hold off on my other question. I'm not trying to raise your blood pressure.
J.M. Thornberry v. State, 1877.
We're gonna argue a case that's that old.
That's the best case to argue. The older, the better.
You can put in the chat.
The only time that they can argue anything against it is when it's been superseded by a new opinion that overturned it. If they don't overturn it, it's still valid, no matter how fucking old it is.
Have they overturned it, you think? Yet?
Mm-mm.
Okay.
They can't overturn it because the Constitution hasn't changed.
Okay. So can you put in the chat?
I want to see if I can find the case first. I've got it cited in this motion. I don't know if I have it on the hard drive separate. I got to find it.
And that's actually not one of the ones on my list here.
Thornberry v. State, 1877. Not the one that I'm looking for. The one I'm looking for specifically says that the power to prosecute in the name of the state is a constitutionally delegated power. It specifically says that. This was talking about when the complaint doesn't originate with a county or district attorney, that it's invalid, or the charging instrument rather. That's what Thornberry says. See, an ex parte Ernest Greenwood. The court affirmed holding that provided that proceedings in the corporation court should be commenced by complaint. Okay, the ex parte Ernest Greenwood is the one that fucked up back in 1957.
Yeah, I said that long ago.
Ernest A. Bell case. By the way, that's a cousin of mine.
Wow.
The Court of Criminal Appeals relied on their previous constitutionally and statutorily incorrect ruling in ex parte Greenwood, and that they did. And Bass v. State from 1968, that's the original case.
Bass is? Okay.
Bass is. Bass v. State, 427 Southwest 2nd, 624, 1968.
Okay, well, can you put that in the chat? I see, I got Bass on my list.
I can put the citation in the chat.
Yeah, that's what I mean. All these cases I have are regarding the complaint.
Well, that was not about the complaint. That one's about the city attorney being able to prosecute.
Right, but if that one's on this list too, that Brett created this complaints in lieu of primary pleadings. Bass is on here. Cool.
Hey, Eddie, what do you use for case citations nowadays since case law or case text has gone away?
Well, I do most of my research on Google Scholar, but I also use Justia and a bunch of other places.
And in Fast Case, you can do them on Texas Law Library. That's a really good one.
If you haven't looked at Court Listener, I highly recommend it. It's an open source kind of approach at it.
I do use Court
Okay.
Listener. It's one of the other ones I use.
Every time
And
I
case text hasn't gone away. It's evolved.
Oh, evolved.
Well, they got a paywall up in front of it now.
Isn't that same thing with Case Court Listener?
Nope.
The new challenge to the city attorney motion is 81 pages long, and it's still not complete yet. But I guarantee you, there is not a fucking hole in it they can squeeze through. The only way they can beat this motion challenging a city attorney to prosecute in the name of the state is to just throw the fucking Constitution out the window and say we don't give a shit.
And they do that too.
No, they don't do that either. Not unless they want to get fucking hung. They don't do that. They make a ruling that says that the people of Texas is going to fucking string them up.
How are they going to find out about it?
There a
won't
version
be
of that
hard.
motion I can get my hands on, Eddie?
What?
There a version of that motion that I can get my hands upon?
Well, the problem is this one's a paid motion. It's not a free motion. And this one, like I say, this one's not done. It's not complete yet.
But you can't bring up any of those things anyway in this appeal that you didn't already bring up. So
No, you can't.
Well,
All
if I have
for
another-
now is study.
Yeah, if I have another municipal case,
yeah,
then that's where it would be useful at.
that's for sure.
But I mean, this one goes into everything, and it sets up every issue. Is the prosecutorial power of the state a constitutionally delegated power? And it absolutely is. And it goes through every part of the Constitution that says so. Article 5, Section 21, the prosecutorial power of the state shall be vested. And it specifically says it's vested in a county or district attorney. Can't be vested in anybody else.
Thank you, Eddie.
Yep.
You want your heart racing?
Go ahead, Jane.
Okay. I'm don't holler. Just answer the question. Okay. I was asking you. You were saying that in Texas, that in order for an officer to write a citation to you, they had to witness the crime in person, right? I think that's how you said it. But anyway.
It has to be in their presence or view.
Okay, well, when you reference the things that you reference, and I go back and read them, they don't say that they have to be. It says that they may. So how am I going to have to out of there?
Again, if the officer is going to issue a citation, they have to base it upon an investigation and a set of facts. An officer that writes you a citation is summoning you to court, but based upon what facts and evidence?
Okay.
If they didn't witness it, then they had to have investigated it. If they never investigated it, they never acquired facts and evidence.
Okay.
So why are they summoning you to court with a citation?
Right. And then the video where that comes into play, as using that's part of the investigation, right?
They can call it whatever they want. The fact is the video does not show an actual offense to investigate.
Exactly.
Her affidavit does not state any kind of offense to investigate.
Yeah, I wasn't talking about that case in particular. I was more,
It's still the same comparison, Jane.
Heck,
whether it's that
heck.
case or 50 other different ones.
Yeah.
All right. Everybody clear on their answers for tonight, I guess?
Are you gonna look over those motions or not? Or am
I'm
I
going to
gonna-
try, Jane.
Okay, I know you're busy. I'm just saying it.
It
Otherwise,
ain't just a matter of busy. I'm barely functioning here. I got shit up and running, but I got computers I got to try to find out what's fried in. Bye, guys.